Gary Plunkett here for Hochman and Plunkett, and today we're going to talk about the traveling employee. The traveling employee doctrine in Ohio is controversial, and there is not a lot of law that is easy to understand on this topic. And it is a topic that has not yet been fully addressed by the Ohio Supreme Court. We have a lot of decisions from the lower courts of appeals, but really there is little, if any, consensus on some very important points about this doctrine, and some of the decisions are hard to reconcile. So by traveling employee, I'm talking about a situation where you as the employee travel to a location for your employer to do your job. So the easiest one to think about is a truck driver. Let's say that you are a truck driver and you've got a dedicated route from Dayton, Ohio to Chicago. And you are required to stay overnight in Chicago, get up the next day, get a load, and then drive back to the yard in Dayton, Ohio. So that is the classic traveling employee. Generally speaking, as a traveling employee, you are always in the course of and arising out of your employment. And if you are hurt while you are traveling, you have a legitimate and compensable workers' compensation claim. The big exception to this doctrine of always being in the course of and arising out of your employment as a traveling employee is when you are either engaged in horseplay or you go on a personal errand. The personal errand exception to the traveling employee doctrine is where most of the controversy comes up. And it is typically a situation where you get to your destination and you go to dinner and you are hurt en route to dinner. That is the classic conundrum in this area of law. And basically, in many circumstances, if you get to your location at the hotel and you leave the hotel property and you go to eat or go to dinner, it is a personal errand. And if you get hurt going to dinner or at dinner, it is not a compensable Ohio workers' compensation claim. Now, the controversy comes up, for example, when your employer happens to pay you a per diem while you are going to lunch or dinner. What if it is an employer who provides transportation to lunch or dinner or reimburses you for your lunch and dinner meals? What if it's a situation where part of your union contract requires your employer to find you lodging that either has meals at the hotel or within a certain geographic area near the hotel because eating is an essential function of your job? That's where the controversy comes up, and it is an important doctrine that has not yet been fully addressed by the Ohio Supreme Court. We hope someday it is. Our firm, where does our firm come down on this? This is my opinion. If you are a traveling employee for your employer and you go to eat and you get hurt while you're eating or traveling to eating, it should be a legitimate, compensable workers' compensation claim.